Okay, here we are. Thanks, everybody. We're just at the top of the hour here. I'm going to jump right into this. I want to welcome you to what is our Wealth Protector TV channel. This is where we deliver content. We're just trying to help people, our best strategies, tools, tips on stuff you should know. And I'm Paul Hitchcock. This is attorney Phil Shakurlian, who's a senior partner at the firm, top attorney, speaks across the country. And if you don't know us, we're Barth Calderon, headquartered here in Orange County, California. We've been around for over 34 years. We have about 12,000 clients across the country. We're an asset protection, estate planning, and business planning firm. Also, of course, probate and trust, which is what we're talking about today. And we love giving back to our community. And I will tell you that for anybody that takes the time to come to any of our events. We do about 50 a year, in person, virtual like this, that we give you the opportunity to get one-on-one with the attorney, Phil Shakurlian, for a complimentary assessment of your planning and just, leave your checkbook at home. It's free. We love doing it. Phil will block off time. It can be a call, phone call, a Zoom call. So keep that in mind. If you get triggered with things here that you want to ask about one-to-one with Phil, happy to make that happen. I put a link in the chat there. That's the link to make it happen to get with Phil one-on-one. Just click on that, fill that out. Also, I'll have a QR code up at the end of this slide presentation. You can use that. Lastly, before we get into it, I will say that I'm going to share the slides here, and we'll follow along that way. Yep, Phil, did I miss anything? We good?
No, that sounds good.
Okay. Let me do this here. Big deal. And I'll say that as we get into this, we get many, many calls, 10 a week on probate and trust. People are falling apart. Things are going haywire. This is something to get in front of. So, Phil, let's jump in. Why this matters? What do we need to focus on with these points here?
Yeah, but we'll talk in depth about probate versus trust administration coming up shortly, but you really want to avoid probate and you really want to make sure that trust administration is as simple as possible. And if you fail to plan during your lifetime properly, then your kids are going to face a tough probate or a tough trust admin or whoever your beneficiaries are. Um, it's most people don't realize the risks until there's actually a crisis. We get a lot of calls from people that want to do their estate plan because they've just finished a probate or a messy trust admin for their own parents. And so that's really the I'm here to educate you so you don't have to get to that point. And you can hopefully help make sure your estate's in place and also make sure your parents' estate's in place so that you don't have to deal with it when they die.
Yeah, Phil, and
Um,
I imagine that you and I have talked a lot about this, about your process, but there is uh, you get into actually helping families talk about this from one generation to the next while everybody is of sound mind is when to handle these things. Fair statement?
Absolutely.
Yep.
Yeah. Yeah. So, what typically we see happening that I've got a couple more points on that slide.
Okay.
What we typically see happening is if there's not proper planning in place, the beneficiaries' heirs, they're stuck with frozen bank accounts. They don't know how they don't have the power to run a business if there was a family business. There's confusion on who's the trustee, and if you can't figure that out, that has to go to court. And a lot of extra expenses are generated from it. And so, the proper planning makes things much, much easier for the beneficiaries and heirs.
Awesome. We ready? Want to move on?
Yep. Yep. Let's do it.
All right, here we go. The difference between probate and trust administration.
Yeah, so probate is what happens when somebody dies without all of their assets in a trust. A will does not avoid probate. I know a lot of people think that they do, but they don't. A will just says to the probate court where you want your assets to go. But the only thing that avoids probate is a trust. And for the trust to work, the trust has to be funded with all the assets. If all the assets aren't titled in the trust at death, Then those assets that are out of trust go to probate, and the assets that are in trust go through trust admin. And so that makes it even more difficult because now you got two processes going at the same time. Um, so probate, it's court supervised. It's the process of transferring the assets from the decedent to the beneficiaries. It can take anywhere from a year to 2 years, and cost tens of thousands of dollars to the estate. Trust admin. Oh, and then it is also public. So all of the assets, all of the beneficiaries, everything is there for public record for people to see. Versus a trust, everything is kept private. It's much, much quicker. It can be done in anywhere from 3 months to 6 months. Gives a lot more flexibility, and helps avoid more taxes and things like that. And there's not nearly the cost of doing the trust admin as there is the probate.
Phil, what if you, let's say somebody lives in California and has rental income property in another state and that ends up going through probate, and they have assets in California. What's going on with that? What happens there?
Yeah, I mean, you could have multiple processes going at once for each. So if you have assets in multiple states, they can all be in one trust. Doesn't matter if you're a California resident of any other state. You set up your trust, you transfer all your assets in the entire United States into that trust. And as long as they're in there, there's no probate. But if, let's say, you had a property in California and a property in Nevada that were both outside the trust, your heirs would have to do a trust administration, a probate in California, and a probate in Nevada. And now you're talking even more cost, even more delays, and it's just a mess.
Got it. Okay. We rolling?
Yep, let's do it.
All right. You see this a lot. We have a trust, so we're fine. What do we need to know here?
Yeah. So again, I mentioned this earlier, and I'm going to mention it multiple times because it's the most important thing. Just because you have a trust doesn't mean it's going to do what you want. You need to, one, make sure it's properly funded. So real estate, the title on the deed needs to be changed. Bank accounts, investment accounts, you need to change the title and beneficiaries. 401k retirement accounts, the beneficiaries need to be changed. All of those things have to be funded properly into the trust. And it's really important. You'll go to a lot of attorneys that charge budget prices, and then I'm going to do this for you. This is the hardest part and also the most important part of doing the trust. And so it's important to get an attorney that's going to help you with funding the trust.
And I just want to address a few of the things that are popping up. Please put your questions in there. We will be sharing the slides after this. We'll send a link to these slides to everybody. So that will be right after this. You'll have them. And then Phil, Mark's asking, do you do cross-border planning with Canadian expats? How do we handle that?
Yeah, we can do that. It's Canadian is a lot easier than other countries. There's different countries that have tax treaties with the US and different countries that don't, and that depends. And then there's also different taxes in different countries. Some of them have their own estate taxes and income taxes, and so that has to be it just has to all work together. But yes, we can handle that.
Okay. And then is there a dollar amount of total assets such as less than 200K that does not need a trust or can go through a simple will?
Yeah, that's so no such thing as a simple will. You don't want to use a will at all. If you need a document, it needs to be a trust. But yes, there are ways to avoid having a trust. The law changes every year. This year it is about 200, and it's different for each state. But in California, it's a little over 200,000 in assets. If you have under that, then you can generally get away from having a probate. However, not all institutions follow that rule. You can have a really difficult time. I've had situations where we've tried to do the alternate process to probate to get a $50,000 bank account, and it took 2 years. A probate would have actually been quicker.
Jeez.
Um, yeah, and real estate doesn't count unless it's your personal home. There's some specific rules for that. But if you have real estate, doesn't matter if it's under 200,000, requires a probate. Assets in other states change the rules as well. So it's always best to just consult with your attorney to make sure that whether or not you need a trust.
Phil, do you get into the idea on this beneficiary designation thing? That would be on life insurance policies, I guess 401k accounts.
Mhm.
What is your advice on that?
It's a case by case basis. Most of the time, you want to make the trust the beneficiary, but not always. There may be circumstances where it's better to make an individual a beneficiary. But again, it's something you need to consult with your attorney on a case by case basis.
Got it. Okay. We're moving on.
Yep.
Trustee responsibilities. This is a huge one because, I've been asked to be a trustee in my life by other people before. And when you start looking into what actually goes on, and in my family, I've got three brothers, my parents handled this the right way and we figured this out, but it's not a small issue. So let's dive into this.
Yeah, being a trustee is not something that if you understood the job, anybody would voluntarily sign up for. It's a terrible job to have. There's a lot of stress, a lot of liability, and you've got to keep everybody happy. If you and your siblings get along great, but maybe you have a blended family situation, let's say mom and dad each have their own family, so you have step siblings, and you become the trustee, you've got to make sure everybody's happy regardless of what they want. So the trust may say that one set of kids gets more than the other set of kids, and you got to make sure that set of kids getting less is still happy. Otherwise, they're going to take you to court, and you're going to have to fight that. And when anything goes to court in a trust administration, the attorneys get the inheritance. All the inheritance goes away from the beneficiaries, and the attorneys get it all. So you really want to avoid that, but in the same token, you got to follow what the trust says. So it's a really tough job to have. Um, Typically, as a trustee, you're not personally liable unless you did something so grossly wrong. Um, I guess if you took all the money yourself, you would be personally liable. Um, One of the things that is nice about doing a trust admin versus a probate is there's no bond required, meaning there's no insurance in case somebody runs off with all the money. And so the trustee has that ability. And so it's really important that the trustee does all of these things that you see on here to make sure that they cover their own tail and not upset anybody.
Do you find that for some of these that pay taxes and expenses, are you required to bring in a CPA, for example? Or, what is the liability there?
Yeah, that's a good point. So you as trustee are not required to know how to do everything. You are free to hire your own professionals to help. You can hire an attorney like our firm to do the trust admin, do all the notices, letters, distributions, allocations, getting all that done. You can hire a CPA or tax preparer to do the taxes for the trust. You may have individual income taxes like you guys file every year for your own income, but you may also have a trust return that needs to be done as well, which is a more complicated return. If there's a business, it makes it even more difficult. You can hire, an interim or fractional CEO, CFO, whatever you need to run the business. You've got all that power as the trustee. Well, as long as the trust is set up properly, you should have all that power as the trustee.
What would be an issue where they wouldn't? Somebody just screwed up the language of the trust?
Some of the more basic trusts that you see won't have provisions that gives the power to run a family business. And so you want to make sure that's really clear and not just trustee has power to run family business, but specifically what they can do. And so it's really important that that's in the trust.
How do you advise folks to keep beneficiaries reasonably informed about the trust? Well, reasonably, what does that mean? And that can go awry, right? Because again, we
Yeah.
get these calls all the time, and people say, "Hey, I heard somebody selling the family house. Nobody notified me." And now it's just liability, and people are suing each other. So how do you handle that piece?
Yeah, that's a fine line. The more communication, the better. That makes beneficiaries happy. Most times we see litigation is when the trustee doesn't tell the beneficiary what's happening and they're just left in the dark and guessing. And then their mind starts wandering and they think, oh my goodness, they're stealing the assets or they're going to do this or they're going to push me out or whatever the case may be. So the more communication, the better. But there is that fine line of, well, they don't necessarily need to know everything. And so it's really important that you follow the advice of your attorney handling the trust administration when it comes to communication.
Tom's asking, good question, Tom. Can one of the beneficiaries also serve as a trustee?
Yeah, definitely. That it's very common that we see that. It's not necessarily the best idea if there's the potential for fighting. You're better off getting a third party trustee like bank or professional fiduciary or an attorney. And then that way it it ends up in less fighting. If the beneficiaries don't trust each other and one of them is also the trustee, it's just a natural disaster for not having trust. But if there's some independent party that has no stake in the game, then they're more likely to have the beneficiaries trust them because they really don't care. They're just doing what the trust says.
Yeah, I think from what I've seen, it comes down to the family. If you've got siblings that are tight and the parents are handling it appropriately, I see a lot of times where the oldest child is, picked to be the trustee. They're obviously also a beneficiary. And yeah, so I see that can work, but your point is well taken. And Steve's asking, how do I find a professional fiduciary?
Before we go on, to your point there,
Yeah,
where yeah, families a lot of times point the oldest child, and as long as the kids are getting along, great. But we also see those rare circumstances where kids got along perfectly while parents were alive, but then now it's time to divide up the assets, and the kids had completely
yeah,
different visions.
yep,
And now, not only are the assets going to the attorneys because of the litigation, but now the kids are never talking to each other again.
yeah,
They're
it's
suing
horrible.
each other, and the family's broken up, and the parents are just turning in their graves because all of their inheritance is gone and now their kids don't talk anymore. So if at all possible, a third party trustee is always the best way to go. And
So,
so to Steve,
yeah,
yeah, how do you find the professional fiduciary? Um, you can go to any bank. Most banks have them. The big banks, B of A, Wells Fargo, Chase, all of them, they have their own. I like First American Trust for a corporate fiduciary, but those big bank type ones, they really only accept large estates. Anything over a couple $1 million because they're wanting to take some fees on it. But you can find local private professional trustees. I don't know if there's directory. You can always ask me. I've got a whole bunch of them that I work with that are fantastic and that I trust and do a great job. Um, but yeah, those are the ways to find them.
yeah, good point. Yeah, if you want to get with Phil one-on-one and that's what you want to talk about and what you should be asking, fantastic. All right, and okay, are we moving on, Phil?
Yes.
All right, common mistakes.
Yeah. So we've got a little bit of this. Again, the job of trustee is very difficult, and trustees make mistakes. It's going to happen all the time. We just want to minimize the mistakes that are made and make sure that they don't lead to litigation. That's the goal in trust administration. Avoid litigation. And so these are some of the more common mistakes that you'll see, not understanding what the trust says. That's one of the most difficult things. The language in the trust is written in a way for a court to interpret it, and not necessarily for a person that's not an attorney. And again, even attorneys that don't work in this field, personal injury attorneys, divorce attorneys, they're not going to understand the language in a trust as well as an attorney that does estate and trust administration. So knowing what the trust says is extremely important because that's the rule book that the trustee has to follow. Keeping
Well,
records, mixing, commingling assets, that's super important. That's one of the things where a trustee could be held personally liable. If they're, putting trust assets in their personal bank account, that's a big no-no. You need to have a separate account opened up with a new taxpayer ID number for the trust for all the assets. Um, Delaying distributions, this one is actually one of the most common contentious points that we see. A lot of beneficiaries like it's been 6 months, it's been a year, it's been 2 years. I still don't have my inheritance. What's going on? The trustee has a lot of flexibility with distributing the assets. And the reason being is there's a lot of things involved. You know, you may not want to sell a house right away. Maybe the market's bad. Maybe the interest rates are bad. Maybe the house needs to be fixed up. Maybe it's, you know, a hoarder house, or, you know, putting $20,000 into a decent house could make it sell for 100,000 more. There's a lot of reasons why there could be delays in distributions, and the trustee has a lot of authority. But the trustee can't just sit there for 2 years and do nothing either. They have to, you know, have to have a game plan.
So there's
Uh,
no timeline that's spelled out for doing things. It's just the judgment of the trustee.
No, the word that you typically see in 90% of trusts is reasonable time, and
Yeah.
reasonable is such a vague term for intentionally it's a vague term to give that power to the trustee.
Yep.
Um, Taxes, you know, ignoring taxes and expenses, this shouldn't be ignoring, it should be failure to understand taxes. There's a lot of taxes involved when somebody dies. You could potentially have an estate tax, you could have a capital gains tax, you could have an income tax, you could have a property tax reassessment. There's a whole bunch of taxes involved, and things like property tax, you may not even know for a year because the assessor's office is so far behind that the property taxes went up. And then say you as the trustee did the trust administration in 6 months, got everything distributed, you're done. And then all of a sudden you get a $40,000 tax bill from the county assessor. What are you supposed to do? Try to claw back that money from all the beneficiaries at that point? Somebody's
Yeah.
got to pay it. So that's really important, something that we see as well.
Okay.
And then we already talked about communication.
How disputes often begin.
Yeah, you know, we like you can see on this slide, we talked about a lot of this. Communication is the biggest one. Timing is probably the second biggest. Well, actually, before that, not having the proper trustee is the first biggest one. We talked about that. Having somebody that is a beneficiary and trustee just automatically um, gives the sense of distrust among the beneficiaries. Having multiple trustees is a death nail. You know, having two people try to make a decision together is always
Oh,
difficult.
yeah.
And so we see tons of litigation revolving multiple trustees. Um, and then, you know, there's just some things that are never going to be fixed, like the emotional part of this. You know, you have the situation where one child feels like another child was favored all their life, and that child was always left out. And so it's going to be tough to appease that child. It feels like they were always left out, and they typically want to go straight to litigation no matter what. But you can put some safeguards in. There's something called the no contest clause that if a beneficiary challenges a trust or a will or a healthcare directive or something like that, and they lose that challenge, they can be completely disinherited. So there are some things that can be done, um, but you know it's hard to avoid disputes. And back to the first thing that I said, proper drafting of the trust is the number one thing that's going to avoid the disputes. And then the second one is going to be communication.
Yep. And Alan's asking, can I get a recording of this webinar? Yes. In addition to the slides, we will send out the recording as well. So yeah, we are recording it now. And yeah, I just always go back when I see these disputes. It's hard. So many family dynamics, but God, if you could figure out where the parents, while they're of sound mind, that they sit the kids down and have an open dialogue. Say, hey, this is what we're doing. Here's the trustee. This is how it's going to roll, and at least sets the table a bit there. Okay, rental properties in a trust, Phil. Let's walk through this.
So property having real estate in the trust is an absolute necessity. Again, real estate doesn't pass without probate unless it's in a trust. So how do you get it in the trust? First, we talked about this, title it correctly. The deed needs to be filed with the county recorder saying that you as the trustee of your trust is now the owner of the property rather than you as an individual. If it's separate property, if it's community property, if it's joint tenancy, we can work with all that, still get it in your trust and still make that work out for you. Then the trust needs to basically say if what happens to that property. You know, a lot of times the person that dies has done their trust and they've given the trustee carte blanche power to do whatever with it. that's fine. That can be done. But if you have a specific provision, it needs to be put in the trust. Maybe you want to see the property kept in the family. Maybe you want to see it sold. One of the issues in California is Prop 19. You used to be able to pass on rental properties to your kids and keep the property tax basis. That is no longer the case. The property taxes are going to be adjusted to fair market value, and a lot of times that gets cost prohibitive. If you're charging a low rent and the property tax goes up, 10, 15, $20,000 a year, you've got to raise the rent $1,000 to $2,000 a year. And if you're only charging 2,000, I'm sorry, yeah, 2,000 a year. If you're No, I didn't say that right. You got to raise it 1,000 to 2,000 a month. And if you're only charging 1,000 to 2,000 a month, doubling the rent, you're going to lose your tenants.
All
And so
right.
you may be forced to sell it. And so that's part of what the trustee has to decide, and why they have a reasonable time to do things. Um, and then a big misconception is protecting your asset. Putting your rental property into a revocable trust, which is what we've been talking about all along, does not protect that asset while you're alive. If the trust is set up properly, it will protect it for your beneficiaries. And when I say protect, I mean from lawsuits, bankruptcy, divorce, things along those lines. Um, a
Hmm.
trust written properly will protect it for your beneficiaries from those threats, but it will not protect it for you while you're alive. So if you want to protect your rental property while you're alive, you need to do asset protection, LLCs, irrevocable trusts, things along those lines. And that's something that we do as well. If you have questions about asset protection, it's a whole nother topic. We have lots of videos on our channel, and I'd be happy to do a free consultation to discuss that with you as well.
Yeah, yeah, a lot of people get into that because they hear this, and there's 40 million lawsuits filed in the U.S. every year, and we do a lot of asset protection for rental income property owners. And to Phil's point, you know, uh, Phil gets into, owning it properly, trust, no asset protection. We see with this transfer of property, they'll have a family property, rental, or a house, and then they'll decide, parents pass, now it becomes a rental property. You see this, Phil? And they don't think of the asset protection thing because it's always been a family property. Now they have tenants in there, and this is where they can get nailed.
Yeah.
Yeah. Okay. Plan for transition. Do we get that one?
Yeah, I mean, somebody has to have authority to do that. You may have holdover tenants, or if you want to sell it, you need to get the tenants in there out. You need an attorney to help with that. Um, California, especially, I mean, there's a lot of states like this, but California has just terrible, terrible laws for property owners, and getting tenants out, whether they're a holdover or you're trying to sell it, whatever, has a lot of negative legal consequences. So that's really important that the trustee has the ability to hire an attorney to help them with that.
Got it. Okay. Closely held business challenges.
Yeah, this one is, again, this is one of the toughest things. You got to make sure that the trustee has power. If a business doesn't have somebody running it for, even a week, it can be catastrophic. If the vendors are used to dealing with one person and that person disappears, how do they know who is the person in charge if there's no trust that says who's in charge? And so they're not going to just deal with any family member. They're just not going to deal with anything. And so you may not get shipments of supplies that are needed to run the business. Um, Employees may not know who their boss is anymore. They may quit. You may not be able to deal with payroll and even pay your employees for that matter. It's just it can catastrophically sink a successful business in a matter of weeks if there's nobody to step in and take over. And if the trust is silent, then you may have to go to the courts, and the courts are not quick. That can take anywhere from 3 to 6 months just to get the authority to run the business. And by then, what's happened?
Yeah. Yeah. And Phil, I've heard you talk a lot related to this about, excuse me, where family have family business, and one kid works in the business, one doesn't, and you get into trust planning and making it fair where you wouldn't necessarily divide up the business 50-50 with the two kids because one works there, has put, sweat equity in it. How do you handle that? What are some of the issues around that?
Yeah, it's a tough conversation to have, but it's something that we do with the clients, and basically it is, how do you want that business to go? Do you want, maybe the business is worth 1 million and there's real estate worth 1 million? Do you want the kid that's involved in the business to just get the business and that's his million, and the other kid to get the real estate? That's one way to do it. Maybe you want both kids to inherit the business, but maybe one kid inherits voting and control shares and the other kid inherits non-voting and non-controlling shares. So there's still equity and both are making money, but only the one kid gets to run the business. You could sell the business, you could transfer to employees. There's a whole bunch of different ways that you can deal with that. And that's a conversation that we have with a business owner when we're doing their planning.
Yeah,
You
we get
know,
into a lot of those issues with business, transitioning to the next generation, whether the kids work in it or not, and even making sure the business is healthy from an asset protection standpoint. I know, again, another topic, but okay.
Yeah, and before we move on, not just talking about when the owner of the business dies, but also what if they were to become incapacitated? What if they get divorced? What happens when they want to retire? There needs to be a business succession plan in place as well, and so we deal with that too.
Yeah, because divorce can be messy, right? Because
Yeah,
especially in community property states where it's 50-50 ownership of things, right?
could you imagine your ex-spouse owning half of the business you worked hard for? That would be terrible.
Yeah. Yeah. Okay. How poor planning creates problems. Anything we missed here we need to cover?
Yeah, let's talk about it. Just because you have a trust doesn't mean that it's going to do what you want. Not all trusts are created alike. Not all attorneys are created alike. There's good and bad professionals in every profession. There's good cops, there's bad cops. There's good doctors, bad doctors. Same with attorneys. And not all attorneys have the experience with estate planning, with things like asset protection and tax planning, to make sure that you are going to accomplish the goals that you want when you pass away. So make sure you have, business succession plan. Make sure you have the trust is funded. We talked about. Make sure all the beneficiaries on all the assets are right, and that your split of the beneficiaries is specific in the trust. Make sure there's only one trustee. Try to use a professional trustee. All these things that we've talked about. But then the other thing is, let's say all those are correct. Trusts need to be updated. I guess the first time that a trust needs to be updated is if there's a change in your family structure, if there's a birth or a death, or maybe there's a new marriage, a blended family, things along those lines. You may need to update your trust then. But even if you don't have those situations, or when your financial situation changes as well, if you have a significant increase in wealth or a significant decrease, that you would need to change your trust as well. But let's say none of that happens. The laws change. It used to be every 5 years you should have your trust reviewed, but now it's really every time there's an election. Unfortunately, our country has become extremely polarized, and every time one party gains control over the other party, everything that first party did is undone, and new laws are put in place, and that affects your trust and your death. So really, anytime there's an election, you should have your trust reviewed.
Yeah, no, well said, well said. And I just put, as we get close here to the wall, I just put the link again to everyone to get one-on-one with Phil. Click that. Got a few more slides here we want to blaze through. Phil, what about this?
We talked about reviewing, keeping your chat fund. I think we talked about all of this here.
Got it. Okay. Plan for the unexpected. Where I want to say that because we get a lot of unforeseen things coming into the law firm. A lot of unforeseen liabilities that are lawsuit related against owners, rental property owners. That's a big deal for us in this category. It's unexpected things that happen in life, and life throws you a curveball. I think many of us have probably experienced that with injuries and people passing away unexpectedly. And so uh, I think it just goes without saying that stay on top of this document. It is your family sort of script to lay things out. Um, Key
Bottom,
takeaways.
staying on top of things now. Um, the earlier you address issues, the better. You know, when trying to do a business succession plan, when you and your business partner are starting off fresh, you guys are on the same page. You have, the same goals. And it's much easier to put a plan in place than if you've been in business for several years and now your interests and pathways are starting to divest. Um, Same with a marriage. You know, if you have a blended marriage, in the beginning, everything's great. You might be on the same page, but as time goes on, you may not be on the same page. And so getting it done quickly and as soon as possible is always the best way to go. There's better tax savings, there's better asset protection savings the sooner you get things done. So don't wait, do it now.
Got it.
Um,
Any key
and
takeaways here, Phil? Anything jumping out at you?
Yeah, I mean, we talked about all this. Remember, you got to update your trust and have it reviewed all the time. Being the job of trustee is tough, but you may be called on to do that. Hire experts to help you out so that you don't make mistakes. Special needs planning. We didn't talk about that. It's something else that we do, but if somebody's receiving government benefits, welfare, Section 8 housing, disability, you name it, we can make sure that inheritance doesn't disqualify them from those benefits. Medi-Cal is a big one as well. Um, Try to communicate with the beneficiaries as much as possible as a trustee. Make sure the assets are funded in the trust, and planning is everything. Get things done early.
Awesome. Last but not least, if you want to use a QR code, take a picture of that. That gets you with Phil as well. We want to say thanks everybody for being here and stay tuned with us because we are doing these webinars and giving out info about every 2 weeks, and we record them, getting out to everybody. So look in the next 24 hours for the recording, the slide deck. We'll send it out to you. Look for your email, and you'll be able to download that. Phil, as always, appreciate your time very much, and want to say thanks to everybody for being here, and thank you, Phil.
Thanks for listening. I hope to see each one of you individually.